Has the applicant a right to the commission he demands? The court finds that as Marbury's appointment was complete, he has a right to the commission. If he has such a right, and that right has been violated, do the laws of this country afford him a remedy? The court finds that they do. It remains to be inquired whether he is entitled to the remedy for which he applies. This depends on, first, the nature of the writ applied for, and second, the power of this court. First, this then is a plain case for mandamus, and it only remains to be inquired whether it can issue from this court. To enable this court then to issue a writ of mandamus, it must be shown to be an exercise of appellate jurisdiction. It is the essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a cause already instituted, and does not create that cause. To issue such a writ is, in effect, the same as to sustain an original action for that paper, and therefore seems not to belong to appellate but to original jurisdiction. The authority given to the Supreme Court by the Act of 1789 to issue writs of mandamus appears not to be warranted by the Constitution, and it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. The question whether an act repugnant to the Constitution can become the law of the land is a question deeply interesting. This original and supreme will organizes the government and assigns to different departments their respective powers. It may either stop here or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description. The powers of the legislature are defined and limited. That those limits may not be mistaken or forgotten, the Constitution is written. To what purpose are powers limited if these limits may at any time be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. The theory of every such government must be that an act of the legislature repugnant to the Constitution is void. If an act of the legislature repugnant to the Constitution is void, does it bind the courts and oblige them to give it effect? It is emphatically the province and duty of the judicial department to say what the law is. If two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must decide that case conformably to the law disregarding the Constitution, or conformably to the Constitution disregarding the law, if the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply. Editor's note: the court held that the Congress, in passing the Judiciary Act of 1789 and giving the Supreme Court the authority to issue writs of mandamus, in effect modified the original jurisdiction of the Supreme Court. That jurisdiction is set by the Constitution, and therefore may only be altered by formal constitutional amendment. Chief Justice John Marshall argued that while Marbury had a right to his commission, the court did not have the authority to issue the requested writ of mandamus. It did, however, have the power to declare an act of Congress void and unenforceable. Marbury v. Madison, then, is the judicial birth of the court's power of judicial review.